um, thank you for joining or finding time to join us today. My name is Stella Duru. I'm a partner of the law firm of Banwa and Ighodalo, and I would be moderating the session today. It is the NBA-SBL Business Weekly Series 21. So we've had 20 other business weekly series before this one. And this is one that is particularly holds a very unique place in my heart, because we would be speaking about the Nigerian electricity supply industry, the power sector. Anyone that knows me and knows my my career journey knows that I'm very invested in what happens in the Nigerian power space. And just to give a brief overview of what the business series is about, it is a knowledge sharing platform of the SBL, and it's basically to help with a platform to talk on topical issues that touch on varying and various sectors and industries. And today we would be x-raying what's going on in the power sector. And afternoon, to do justice to the topic that relates to the developments in the legal and regulatory framework for the Nigerian electricity supply industry, is a partner of Oak Legal, Mr. Chukwuike Nato, who is, I would say, has very vast knowledge about the sector where we play. And he has graciously put together very interesting presentation slides, which he would take us through this afternoon. He would be taking us through the journey of the sector, and then, finalizing and touching on what the recent developments are. We're hoping at the end of his presentation, we would be seeing the light at the end of whatever tunnel we continue to find ourselves in as it relates to the Nigerian power space. And hopefully after today, I should be able to speak to my nephews and my niece when they talk about blackouts. So he's going to take us on what the legal and regulatory framework looks like going into the future for the sector. So before I hand over to him, I would encourage anyone that's got comments to put them in the chat box, but specifically if you've got questions and answers or questions for the speaker, we'll be happy to see those in the Q&A chat box, and we would try to take as many of those questions as possible after the presentation. Chukwuike, over to you. Thank you.
All right. Thank you, Stella. Just to confirm, you can hear me?
Yes, loud and clear.
Right. And thanks again for the intro and for doing this, keeping us honest in this process. And I want to also acknowledge the NBA-SBL Council under their chairmanship for this opportunity. This series generally is a very useful tool for lawyers, business lawyers to follow up, keep up to date with what's going on in their various sectors, and also develop their technical competence in what we all hopefully love to do. Well, for me, I love to be a business lawyer. Today's topic, I think, is interesting, and I know I'm not the most objective person on that question, because I'm the one presenting on it. But I think with everything that has been going on in the Nigerian electricity industry, this is a particularly interesting topic to take a very quick look at in the little time that we have. Stella, you said that hopefully after this, we'll see the light at the end of the tunnel. And it reminded me of some funny video I watched recently. And they were asking, why does the light have to be at the end of the tunnel? What will you be doing with it after you have gone through the tunnel? Hopefully, we will get the lights at the beginning of the tunnel, both in the context of what's going on in this industry and generally. So what we will do today is quickly take a quick look at the background, the context of the topic of what we'll be discussing today. We'll run through the developments and how the industry has evolved over the past maybe 20 years. And then we'll take a look at the framework, legal regulatory framework, as they were designed, and then we would narrow down to the more recent developments, after which we should conclude, take questions, discuss a few of the issues, and then call it a day. So thanks everyone again for coming in here. Now, why do we need to do this? And this is not, this part of this presentation is not just relevant for today's topic. Generally, it's what I think of what SBL is doing with this series and their other efforts at growing business law in Nigeria. Economics, we've all had a bit of training in it at some level, primary school, secondary school, perhaps for some multidisciplinary lawyers at graduate and postgraduate level. Economics is the study of human behavior and their economic choices, right? And everything else that affect those choices, price, costs, what's available out there in the market, demand, supply, all of those basic principles of economics that we know. It is very similar to law also. In fact, some persons believe that law is itself, clearly it's a social science, but perhaps among all the social sciences is most similar to economics in the sense that it looks at different, it tries to influence behavior, predict behavior, and in some cases, punish behavior, incentivize certain behaviors and punish certain deviant behaviors. That is what law is, right? And it is, in my opinion, and I'm sure an opinion shared by several persons, is a very efficient tool for changing behavior in the market. And there's that blend between law and economics. In fact, it's a very detailed area of study on its own, law and economics, and how they interact to grow an economy, grow an industry, and both at the micro and the macro level. So today's series hopefully will be another opportunity for us to gain a better understanding of how the law can influence behavior, particularly in the Nigerian electricity supply industry. So I'm sure I'm going to run through this part of the slide because it's mostly historical context, but the key things to know is that the Nigerian electricity industry used to be a vertically integrated industry where you had a single monopoly, Nigerian Electric Power Authority, NEPA, that was involved in all the value chains of the industry, generating power, distributing, transmitting power, distributing power, and it owned all the assets across these value chains in the industry. But over time, there was a lot of inefficiency in that process, right? Perhaps because most of that activity was concentrated in one single entity, you find that inefficiency at one level tends to cascade down to all the other parts of it, particularly where some of these inefficiencies are institutionalized within NEPA, as it were. So over time, both in the context of Nigeria's unique experiences and then with what was emerging as global best practice, it was decided that the industry needed to be unbundled. And the key events that happened with those started, I believe, in 1998 with the amendment of the Electricity Act and the NEPA Act, which created the state-owned monopoly. And then in 2005, when the Electric Power Sector Reform Act was passed, which till date remains the primary legislation governing the sector. And then in 2000, I think it was also in 2005 that NEC was established and NEPA became Power Holding Company of Nigeria, and then the Power Holding Company of Nigeria became the 18 successor successor companies in the industry, constituting of the generation companies, the distribution companies, and then the transmission company of Nigeria, TCN, which remains the only nationwide monopoly surviving from the NEPA days. And then in 2013, when all of these companies except TCN were privatized and went from government ownership to private ownership, it's become a recurrent debate about whether the 2013 privatizations have achieved their purpose. I mean, everybody will remember the popular "where is the power" remark of the Nigerian president saying with all the investments in the sector and everything that has happened, where is the power? Where is the power? An understandable question, but it is also something both in that narrow sense and generally in the sense of all that has happened in the sector, the legal regulatory review, the privatizations, the commercial deals and everything else. It may not be as simple as saying that it has not worked. We still have insufficient power, which is correct. We still have inefficiencies in the system, which is correct. We still have significant liquidity challenges in the sector, which is correct. Those are all correct, but my personal view is that we are, if not in a better place than we were pre-privatization, I think we are certainly on a better path to where we need to be. So does that make me a bit of an optimist? I don't know, but my opinion really is that we have grown both as different operators in the industry and consumers also. And if nothing else, we are at least on a path to where we all expect to be, which is where the supply is sufficient for the demand and the different investors in all of the value chains of the industry are able to get returns or reasonable returns on their investments. So that is as far as it goes with the history. The basic legal regulatory framework in the industry started with the National Electric Power Policy in 2001, which essentially drew the map of the reforms that happened in the industry. That then succeeded with the enactment of the EPSR Act, which established the sector regulator, Nigerian Electricity Regulatory Commission, and then created all of the processes for the transition from public-owned entities to the private-owned entities across the value chains, generation, distribution, transmission, and then system trading and system operation and trading, electricity trading in the industry. Now, remember we said the EPSR Act created the sector regulator, the Nigerian Electricity Regulatory Commission, NEC or NERC. NEC is the primary regulator in the industry today, although because the NESI involves interaction across different industries, right? There's upstream oil and gas, there's the electricity sector itself, and all these other ones. There are, of course, some other agencies, environmental protection, even competition control and all that. There are some other agencies that will have a say typically in any electricity project, but NEC is the primary regulator. And they are the ones that have been empowered by the EPSR Act to make regulations, and regulations are their most powerful instrument in regulating the sector. And some of those key instruments, mostly regulations, are here. We've got the license application regulations. Now, because this is a regulated industry, right? You cannot carry on any activity without a license issued by NEC. And those activities are, of course, generation, power transmission, electricity distribution, and trading. Trading, the rest may be self-explanatory, but trading is simply buying and reselling power in the industry. The most common, the most popular trader that is done in the industry today is the Nigerian Bulk Electricity Trading PLC, the bulk purchaser. It will have a little bit more on the NBET later on in this webinar. And then the other key regulations are the investment in third-party networks, the investment regulations of 2015. Now, and again, remember we said that each of the operators in the industry are licensed by NEC, and part of literally what they are licensed to do are to build, to own, and to operate assets and networks, generation assets, distribution assets, transmission network, and all of those. Occasionally, some of these assets are inadequate for what the licensed operator is approved or permitted to do. And so the investment regulations of 2015 created an enablement for private parties who are not licensed to invest in some of these networks for better operations of the licensee, and then creates a mechanism for them to recover their investments, even though they wouldn't own it. Naturally, the assets will be owned by the licensee itself. Then there's the more recent eligible customer regulations in 2017, which was a very interesting development in the industry, because prior to that time, by law, a generation company that is connected to the national grid can only sell power either to a distribution company or a trader, the bulk trader in this case. Now, the eligible customers are the third persons that generation companies could sell power to. But the generation company's ability to sell to eligible customers was suspended until the minister makes an order to that effect, and that happened in 2017. The regulations required any person who is able to take a minimum of 2 megawatts of power to buy that directly from a power generating company and not have to have anybody in between. Now, contractually have anybody in between. But to get power to that eligible customer, of course, in most cases, you go through the transmission network, and in some cases, you go through the distribution network of a licensed distributor. And then there is all the tariff orders that NEC issues controlling what can be priced in the industry. The other key instrument was the partial privatization order that NEC started sometime, I believe, last year, and all that. We'll speak a little bit more on that later on also. Now, NEC, generally, by the EPSR Act, is required to be independent of the government. The point being that it should be able to take its regulatory decisions without political, perhaps, interference or any other kind of undue interference from anybody, really. And the objective ultimately is to have an efficient market where where foreign investors' interests are aligned with consumers' interests. And these two are not necessarily meant to oppose themselves. An investor in the business should be able to price its product in a manner that enables it recover and make more investments. The consumer, of course, should be able to enjoy the product that it is paid for, and also not have to perhaps suffer the inefficiencies of the person supplying that product to it. So generally, the next objectives or powers were to promote competition, to monitor and operate the market, to protect consumer rights, to promote safety in the industry, and then license operators generally. So that is the default position of the industry. But recently, there have been some key developments that will now form the crux of our attention today, really. So the first was the partial activation that NEC implemented or commenced last year. In simple terms, partial activation was NEC's way of attempting to maximize the transmission network and ensure that every power that is able to get on the grid does get on the grid, and that having gotten on the grid, that power gets to the ultimate consumer. Now, I've tried to simplify this concept because if you follow the industry, you will find a common event where the different operators blame themselves for what happens in the sector. We have a national grid that is meant to have the capacity to wheel power of up to, on the average, 5,000 megawatts, although data from the industry suggests that it rarely, if ever, gets to that capacity. You've got, again, by the records available, generation capacity in the country that is in excess of maybe 12 gigawatts, about double the capacity that the TCN can take. which already shows that mismatch. And then you've got the distribution company, which is everybody's favorite. I don't know what to call them. Everybody loves to blame them for everything, perhaps because they are the ones closest to the industry. Now, the partial activation was meant to deal with whatever made it impossible for all the power generated to get on the grid, and whatever makes it impossible for the power that gets on the grid to then get to the different discos and to the final customer. So NEC tried to deal with the problem both from the very first step of fuel procurement, depending on the nature of your generating plant, what your fuel inputs are. Majority, a huge part of Nigeria's generation comes from gas. And then the others, hydro is also a major source, and the rest, some other minor sources of fuel. But gas is a huge part of our generation capacity. So NEC tried to get generating companies to have very firm fuel intake agreements, and then between the generating companies and the bulk trader to have a very firm, what they call an activation agreement, which is essentially a power purchase agreement. And then between the generating company and TCN also, what they call a power evacuation agreement. And the point being to make sure that whatever inefficiencies across the value chain that was on one hand underutilizing the available capacity of the TCN network, and then on the other hand, causing supply deficiencies or supply deficits to the final customer, to make sure that all of these inefficiencies are treated, and that at every point in time, you've got maximum power available for the maximum capacity of the infrastructure in the industry. So the key agreements, like I've mentioned, that the partial activation implemented was the activation agreement between the generating companies and the bulk trader, and then the power evacuation agreement between the TCN and the GENCOs. It is unclear what the status of the partial activation program is right now. Depending on who you ask, the intended objective of ensuring increased supply in the market may not have been achieved. We still experience very significant supply deficits and blackouts, if you like, in the system. To what extent those are still a result of a failure of this program is all debatable. But at least it was an attempt to try to address those inefficiencies. And this part is my personal opinion, right? I think the program may have underachieved as far as its objectives were concerned. And a lot of it, which is probably relevant to the audience today, a lot of it was because of the setup of the legal documents that implemented the program. The activation agreement, for instance, in my opinion, may not have been fully, it didn't fully address the issues that existed prior to the partial activation program between the generating companies and NBET, right? In most cases, you had generating companies whose investors had made significant investments in building a power plant, but they are not able to get firm power purchase agreements. And what I mean by a firm power purchase agreement is an agreement that guarantees that the capacity of your plant is taken off at the level that enables you make, even if it's just to break even on your investments. So what was happening before then was that most generation companies were on what they called energy only contracts with the bulk trader, where they were paid only for the power that was put on the grid. And the generating companies didn't have control over the power that was put on the grid. It depends on the power that they get dispatched. And sometimes they get instructions from the system operator to ramp down or turn off their generators in simple terms and all of that. So they couldn't predict their revenues. They couldn't forecast their numbers, and it impacted heavily on the investors' appetite, and also cost, obviously, lost revenue, lost investment, and all that. We don't think, well, I didn't think that the activation agreements fully acknowledged that. So you had an instance where a generating company that didn't have an activated agreement at all, a firm agreement, was then having a particular capacity being activated. And it begged the question, what exactly are you activating? You know, you can't build nothing on nothing. There were perhaps other factors that affected the partial activation. Maybe the legal documents may have been too much of a template. It didn't really allow the contracting parties to fully negotiate the unique issues, whether they are legal or commercial or technical, between them in their agreements. NEC just got the document and got everybody in a room and required them to sign it, literally. That was what happened. And then, of course, stakeholder consultation. NEC would never agree to this because, in fairness, there was some noise around the program, but whether or not that was sufficient before the program was launched is a matter for debate. So those, I think, were some of the factors that may have limited the success of the partial activation. But in theory and as a concept, I thought it was at least an idea that asked the important question: if we had this much capacity for evacuation of power, why aren't we using it? If we had this much generation capacity in the country, why don't we have it on grid? And if the discos are, as they claim, not to blame for the final deficit to the customer, then what is the issue and how can we address it? So the program did ask those important questions, but again, the answers are still out there. A very minor point on the Business Facilitation Act, right? I counted it as a recent development because it's an interesting piece of legislation. It essentially put a mandate on regulators generally to be more efficient in their decision-making as far as regulatory decisions were concerned. And it required every regulator, well, it called it ministries, departments, and agencies. It required them to publish their list of requirements and state the timelines for them to make their decision. And if that timeline passes, and as long as you've met those requirements, you, as an applicant, can deem that your application has been approved. Again, I think it is well-intentioned, but it also raised a lot of questions, really, about, I think this law may have started actually as an executive order that then became enacted as a law. The whole point was to make Nigeria more business friendly, and the whole ease of doing business thing, get our index higher up. But again, the question in the context of the Nigerian electricity supply industry was, did it, for instance, amend the EPSR Act, for instance? The clear answer to that is no, because the law was specific as to the other older statutes that it was amending. KAMA, for instance, the Forex Act, and a few other federal legislation. The second question was whether NEC, for instance, is an MDA. I recall in my practice experience, we had to do an opinion once for a party that applied for a license to NEC, and a decision didn't come back in the time that NEC says it should come back. NEC's regulations and the EPSR Act says that a decision for every license application should be taken within 6 months of your meeting the requirements for the application. The client in question considered that it had met all the requirements, but NEC decision wasn't forthcoming. And then the specific question was whether it could deem that it's got a license. This was prior to the act, when it was still the executive order that was in operation. But those are the kind of issues that will tend to come up with this Business Facilitation Act, for instance. So you've made an application, will NEC consider itself a ministry or a department or an agent of the federal government? Depends on who you ask. Again, what is clear is that the EPSR Act says that NEC should be independent of government, in the sense that it should be free from political interference. Others will argue that yes, but that independence does not then make it a law unto itself, that it is still a public institution that is subject to the Business Facilitation Act. Whether anyone can operate in the industry on the basis of a deemed license, again, maybe something that the courts at some point will have to decide on. I am not aware that there is any live case on that issue. And then another recent development was recently the commission approved for 3 distribution companies to exit their NBET contract and procure their power bilaterally from generating companies. Bilateral is simply a 2-person contract. So before now, really, like I may have passed through very quickly in the evolution of the sector. Before now, the NBET was the bulk trader that was brought in to buy power in bulk from generating companies and then resell to the discos. And the point was to help with, to provide payment assurance on one hand to the generating companies, who then are protected from payment obligation, breaches of payment obligation from distribution companies, for instance. And NBT was sufficiently funded to bridge that payment gap. And then on the other hand, to also ensure a more equitable distribution of power across the GenCos, and to ensure that regardless of among the discos, and to ensure that regardless of a disco's commercial capacity, the customers of that disco will get power. So I think it did deal with the vesting contract that put some obligations, some minimum market obligations on each disco to take, to ensure that this power goes round in an equitable manner. Now, Abuja Disco, Eco, and Ikeja distribution companies have now been allowed to exit this industry. And it's an interesting development because it, one, shrinks the market a little bit, because between them, these 3 discos, most industry operators will agree, may be one of the better performing distribution companies. But beyond those economic impacts, this NEC order, if you like, throws up the question of the future of the Nigerian Bulk Electricity Trading PLC as a bulk trader. Right now, the NBET was established obviously by the EPSR Act, and then the original idea was that when the market starts moving to a more competitive market, the NBET was meant to be phased out, and then discos and GenCos will contract bilaterally. That should have happened in 2015, perhaps, when the traditional market was declared by NEC. It hasn't. NBET's license expired, I believe, in 2020 and was renewed for another 3 years. This is the 3rd year now. So at some point, the question of whether or not their license will be renewed will come up again. Although my personal opinion is that with what NEC has now done with these 3 distribution companies, it appears to me that we cannot be certain that NBET's license may be renewed, or even if renewed, maybe not for the term that it had previously, the number of years that it had previously enjoyed. And then the 4th impact or potential for this development in the industry is that we are likely to see a lot more activity, a lot more competition in the trading business. Before now, it was just NBET. But if these 3 discos are now allowed to contract bilaterally for their power procurement, then they may need, again, a trader who is able to purchase in bulk from the generating companies and resell to them. Now, some persons, and this is important for business lawyers, may wonder why, if NEC has said contract bilaterally, why do you then need again a trader in between? Which, I mean, the economists will tell you that those kinds of arrangements will result in double or multiple marginalization, because you then find between a generating company and a distribution company, for instance, the generation company would have only priced for its own profit margins. Now you've got a trader in between who is also likely to have its own margin, and all of these marginal prices get transferred ultimately to the customer. Well, first to the disco and then ultimately to the customer. In fact, the customer alone, because every person across the chain is recovering its margins from what the customer pays. And that is a fair question, really. Why have that extra party, a trader, in there? But efficiency is in itself a cost, right? And if you are going to have a trader who is able to aggregate the power that a distribution company needs and then resell to the distribution company, and then handles perhaps payment issues between the distribution company and the generating company, handles other operational issues, for instance, the interface with the transmission company of Nigeria, maybe handles some of the issues with NERC and the regulations. It does make the DISCO's operations more efficient, translates to value, and ultimately can't be seen as an additional cost, but a process that makes the entire value chain more efficient. And remember, sometimes economic decisions are reduced to Naira and Kobo terms, right? What is the price? What is the cost to me? But by the time you factor in all sorts of issues, efficiency of the process, efficiency of operations, you find that those also should go into a consideration of why you are paying for what you are paying for. So that something may in Naira and Kobo terms appear to be cheaper does not necessarily mean that it's in fact cheaper. If you consider that maybe for that cheaper stuff, you're going to have a higher, you spend more time in searching for it, or you get something that perhaps may not function as optimally or as efficiently as the alternative product and all of those. So the point is this: traders may literally appear to someone looking in from the outside as adding to the process and adding to the cost, but we think that generally they will make power procurement and sale more efficient. I'll run through these slides for time purposes and get into what I think is another key development in the sector. Now, we all know that the president recently signed an act to amend the constitution, and essentially what that amendment did was to devolve more powers, more legislative powers on the industry, on the electricity industry, to the state governments, right? This is a legal audience, so we don't need to go into the basics of exclusive lease and the rest of it, right? But in simple terms, before now, the understanding was that electricity regulation and legislation was the preserve of the federal government, and states couldn't, to some extent. The constitution actually says states could do power generation, power stations, and some of those, but particularly in the distribution and transmission value chain, it was almost exclusively the preserve. In fact, it was exclusively the preserve of the federal government. Now, this amendment appears to have brought in the states into the mix. And it's an interesting thing because on one hand, those who will tell you that the reforms in the sector have failed will say that, well, let's try something different. If we've got a single EPSR Act, if we've got a single regulator, if we've got how many of the distribution companies enjoying quote unquote some territorial monopoly, although please, this is important. EPSR Act does not create monopolies. In fact, Section 76 clearly said that the license you enjoy does not give you a monopoly. But in practice, really, many of these distribution companies have their what is called their franchise areas where they are meant to operate to the exclusion of any other distribution license. There are exceptions to all of that, but we don't have the time to get into it. Now, if we've been dealing with that single law, single regulator, limited distributors who are in defined areas, single transmission company, right? Generation companies who are all on the grid and all of that. If we've been doing all of those for the past 10 years and it's not working or doesn't appear to be working, or at least if you want to put a spin to it, it's not working as well as we want it to work, why don't we try something different? Why don't we throw it open, have more persons in the business, and see if perhaps competition could lead to better output? And again, I'm always careful to say where things are my opinion. I understand that thinking and acknowledge it, but I think that for a number of factors, it is not so simple as to say, throw open the legislative powers. If the federal level is not working, let the states do what they want. For one, the tech people haven't yet figured out how to move electricity without wires, right? It is still, for every single electron, you've got to have a wire moving it from the plant down to the light you turn on in your homes, right? As opposed to the telecoms industry, for instance. That's one. Two, you require significant infrastructure to get that power from wherever it is sourced to the person that has to consume it, right? And for these two reasons, one, it's a wires business. You've got to lay wires overhead, on the ground, at whatever level. And then two, you've got to invest in this very extensive and sometimes complicated infrastructure. The electricity business almost became naturally a monopoly historically, right? Because one, you don't want to have in the same geographical area, for instance, different persons laying different wires, right? It throws up health and safety issues. There are questions of aesthetics, for instance, and all that. Technology is giving more options with these now, underground cabling and all of those things, but it still has an impact on the environment. So you don't want different operators crisscrossing their wires across the sector. And then of course, you also don't want persons who have come to invest in public infrastructure to suddenly have to deal with competition that makes investment in that infrastructure uneconomical. So to that extent, my personal opinion is that it is not always ideal to say the more the merrier as far as the Nigerian electricity supply industry is concerned. And that may be what this constitutional amendment may now lead some persons to believe, that now that you've got the states able to make laws on everything, whether or not there's infrastructure existing there or not, now that you've got that constitutional blessing, then every state could go set up their own sector regulator, license their own distribution companies, set up their own transmission network, and kick it all out. We will see how that goes, but it is a key development, if you like, for several reasons. Now the states are likely to own their own distribution grids, distribution companies and grids, like I mentioned. On the legal and regulatory side, you're going to find investors or operators now perhaps requiring licenses. Are we going to deal with NEC? Are we going to deal with the states? Which is similar to what you have, for instance, in taxation, where you've got multiple taxation at different levels. I mean, on one hand, it really does. I don't think it makes. I don't think it's investor friendly, really. And then there's the question of what the impact will be on contracts that have been existing before now. Now, not usually, the contracts in the Nigerian electricity supply industry are usually long term because you are investing in significant infrastructure. Most of the contracts are designed to last long enough for the contracting parties to recover their respective investments in the sector. So you've got 20-year term, 10-year term PPAs, you've got 20-year term gas supply agreements, you've got all sorts of long-term contracts. And now suddenly in the middle of the operation of those contracts, you've got a significant change in law that could threaten the continued operation of that contract. That is one issue. Now, I think one area that perhaps we haven't fully considered and maybe might be a thought for whoever will have to be faced with the question is whether the doctrine of covering the field will become applicable with this constitutional amendment. Now, we know that the doctrine says that if you've got federal legislation that already covers the field on a matter, then a state law shouldn't apply in that regard. But I mean, different people will hold different views on this, and we'll see how that goes going forward. But perhaps amongst all the recent developments that I've mentioned today, I think this constitutional amendment is the one that is maybe the most topical because it's excited a lot of people, both consumers who are seeing a window of opportunity, perhaps for an improvement in their lives, and then of course operators who may feel that this is an existential threat to their business, and then generally the markets watching how all of these things play out. So, and I'm mindful of time here, these developments in many ways are commendable because it shows that we are still constantly tinkering with the process, tinkering with the setup and the design of the sector, particularly on the legal and regulatory component of it, to try and see what works best. So everyone agrees that we are not there yet. Everyone agrees that there's still work to be done. It's just then getting to the point where we say this is the right way to go, that many of these regulations may throw up different opinions. But I'll say that, again, personal opinion, I didn't think the constitutional amendment was necessary. I frankly don't see that it has changed much or will change much. If anything, I think it might create a bit more uncertainty regulatory-wise in the industry, which is never a good thing for investment, never a good thing for investment. You know, money likes to have a bit of predictability, both as to what it can buy and how long it can stay out there before it gets back to the person who paid it out in the first place. And so I'll say that generally, the Nigerian electricity supply industry is a very perfect example of how law can be a tool for economic development. Everything that has happened in this sector was driven by legal and regulatory changes. It's still being controlled by legal and regulatory changes. Although if you are active in the industry, you would know that there's always this persistent debate between the lawyers and the engineers as to who has more influence in the industry. Clearly, I'll say lawyers for no reason more than I am a lawyer. But the truth is that everything that happens in the sector have been driven by the legal and regulatory framework in it. And the changes, even if minimal, usually have very far-reaching effects. So that is my presentation. And Stella, perhaps we can take some thoughts and questions. Thank you.
Thank you so much, Chubike, for your excellent presentation. I was just nodding and smiling. And every time you said this was your opinion, I laughed because after this presentation, you still need to be able to talk to the regulator as to whatever it is that you have said. So necessarily, you need to put the caveat out there. I would say that I'm sure all our participants are quite happy to have spent this 1 hour, or should I say about 45 minutes, listening very keenly to what you had to say. You touched on where we see the market going. There are questions, you've raised very, very interesting questions. If we're looking at the development introduced by the Business Facilitation Act, for instance, can we indeed, start playing with the deemed approval by NERC if you have put in an application? What exactly is going to be the future for MBET, given where we are with the different mechanics that have been put in place by NERC to deal with the inefficiencies in the market? But we're clearly running out of time. And I see whilst we have one question in the Q&A box, I've got a couple questions that I think you may need to touch on, especially as it relates to the constitutional amendment. Your views on that is very interesting. And indeed, when the law was passed, there was excitement in our firm, I can say that, as to what this portends for practitioners as well as operators in the space. So whilst noting that it's your opinion, how do you think this constitutional amendment will affect the franchise arrangements that we have currently in favor of the discos? We all know that discos have basically, and any disco right now will put an outlook based on revenues from its franchise area. Given what the constitutional amendment seeks to do, which is to give states the powers to make laws on everything along the value chain, how will that impact the revenues of the discos and generally the franchise arrangements in place? I don't know if you want me to take all my questions and then you'll answer them seriatim, or you want to just deal with.
I think you should go. Give me yours. So I'll note them and then answer. Yeah.
Okay, so the second one is, and I think you touched on it. Are we facing a situation, or are we going to be seeing NERC as a super regulator? Whilst we would most likely have regulators coming up for each state, how do we want to ensure that there's collaboration between NERC that has been in the system for this long and the new regulators that will come in place? Are we going to be seeing NERC being conferred with some super regulator status? What are your views on that? And the very last question I have is, and you touched on the issue around, transmission lines and states just, generate or building their own transmission lines. How are we going to deal with that? Are we going to be seeing more grids? Are we going to be seeing state grids, regional grids? How will they work? You touched on the fact that that constitutional amendment, whilst it is commendable, it also could potentially create confusion as we know it in the system. So I'd like to know your views on these three broad areas.
Right.
Thank you.
Okay. Yeah, thanks, Stella. So, to your first question, and I'm going to try and keep it very brief and not make it a little bit too academic, because this is this constitutional amendment is a real deal for consumers, is a real deal for operators, and they are on different spectrum of positivity, if you like. Some persons are very happy and excited, others are mighty depressed and wondering what is going to happen to their investments. So, to your first questions, are franchises threatened? Yes, right? And I hope this, I'm not so important as to have my personal opinions disrupt the market, but the truth is that, does the constitutional amendment present some kind of business economic threat to existing franchises? It does, absolutely. Now, is there a way they can mitigate it? They may want to go and consider the issue of covering the field and see how their lawyers can get them out of those things. But there are a few things there. Because beyond giving legal advice and putting the law and Latin maxims, you also got to be practical as a business lawyer, right? Because ultimately, a businessman just wants to open his shop and do his business, not get bogged down in some disputes, whether with his regulator or potential regulators or deemed regulators, right? So I would say that they should look out for the states who appear, and there are at least 2 states who have shown a clear intention to move in that direction. They should monitor those and get in there. Because guess what? Those existing franchise holders, the distribution companies, as far as the know-how, the transactional experience, the financial capacity is concerned, I don't think any new entrant can compete with them, right? So on a very practical level, I'll say they should watch out for what the states do. And if a state says, I have a new regulator, go get the regulator's license. That's practical, right? But there are, of course, issues that could entail. We don't know how the states are going to price some of those license processes. We don't know what they're going to ask. And then, of course, you've got the question of your existing terms and conditions issued by NEC, whether it is consistent with you now going to get another license. There are ways to deal with that. Get another corporate vehicle, deal with all of those issues. Although NEC also has certain rules about related parties and affiliated parties and what they can do as long as they are a licensee. So they need to consider all of those things. But on a very practical level, I'll say monitor what is going to go on very, very carefully from the states and get in there as a first mover, because they've got the competitive edge financially, commercially, technically to compete with whoever else wants to get in on their franchise area. That's on question 1, I think. I'm sorry if I missed any part, please let me know. On your question on the super regulator issue, my heart says yes, because I am a bit skeptical about the whole constitutional amendment issue. I would rather have one regulator that I know that if I get in there, I can open up shop and start my business. And see, the whole point of ease of doing business, if we recall, when NIPC was first established and all of those things, was to have that one-stop, OSIC, I think they called it, one-stop shop investment center or something like that, where you come in and get all the licenses you need to start your business. Now in the electricity industry, you're now suddenly having to deal with NEC, you're having to deal with NEMSA. NEMSA is the electricity, they deal with the technical issues with your constructions and all of that and equipment. Now, and potentially, based on this constitutional amendment, you are now having to perhaps also deal with the states. So while I say, yes, I think it's good to have one super regulator, I also know as a lawyer, and that's where my head comes in. Remember, I said that my heart's opinion. I know that it won't work legally because it's clearly contrary to the whole federal principle thing, right? You cannot tell a state what to do. And we know from recent events with the up and down change of monetary policy with CBN that when the states mean to disrupt something at the federal level, they can disrupt it. right? And particularly so when they form any kind of band, the governors or the state governments, if you like, it's hard to stop them, right? So legally, I think it might be tough to have that super regulator status with NEC or with any federal agency, but my heart says yes. On your third question, I would say that we already know, and this is public knowledge, that Lagos released their electricity market policy, I think last year or 2 years ago, I can't recall, right? And there was a session we had with their commissioner where there were a bit of back and forth on what they were trying to do. They are ready to move on this. Edo, I think, are also going to move on this. So it looks like it's going to happen, despite the objections of people like some of us. Is it a magic bullet? No, I really don't think so. Are there going to be issues with physical infrastructure where you've got wires crisscrossing the whole place? I'll say yes. And that is even more so for a place like Lagos that has a very high population density. Lagos is, contrary to many people's opinion, is actually a very tiny place, right? So every little infrastructure you put in place takes up a lot of space for a population that is growing at a crazy rate. So even for Lagos particularly, I think there are going to be issues, but I know that they are quite aggressive in moving in that regard. So no, I don't think it's a magic bullet. I would have suggested, if we must tinker with something, to break up TCN, for instance, make it a more regional network, maybe, and have the states, and maybe not just the states, maybe have at a regional level, the states organize themselves into controlling the national grid and all of those things. And listen, I'm not an engineer, but I read or spoke to someone who was explaining to me that the Texas power crisis in 2021, where there was a storm, and of all the 50 states in the US, or at least the states that were on the path of that storm, Texas was the one that suffered a blackout for some time that nobody seemed to figure out how to do. I understand that a key reason for what happened to Texas was the fact that they have an islanded electricity transmission network, and so they couldn't import power at times of emergency, like what had happened during the storm. So those are some of the issues that are likely to happen when this amendment happens and states go in and start building their network. What happens if you are prone to some, I mean, we see it with Kogi State, we see it with some states where you have these seasonal floods. What happens when you have such natural disasters that cut you out from the national grid? What technical arrangements would you have to ensure that you're able to import power? Because what this does, it breaks up the market into different islands. How are you able to quickly import power at moments of emergency? And again, ultimately, and that's a factor that we haven't talked about enough, how will this impact pricing? Because the whole point of pricing in the sector is that some persons subsidize others. When you move a huge chunk of the market out of the market, particularly a chunk that pays best, the likely impact is that pricing for the remnants are likely to increase. So yes, Lagos and Edo, we know will move, but I don't think it's a magic bullet.
Thank you so much, Chukwu Buike. I think we've really run out of time. But very quickly, in 1 minute, I see there's a question from Adenike. And she says, is there no way multiple companies can share infrastructure, or are consumers condemned to suffer at the hands of the discos because of dependence on wires to the detriment of the economy? So that's the only question we can take, and then I think we'll wrap this up.
Right. So yes, it would be ideal for that to happen, but it's, again, we started with saying how law tries to regulate behavior, right? So you are dealing with private parties who are recognized as independent entities by themselves by law. There's an extent to which you can force them to get into a room and do these deals together. So until they see the commercial or technical benefits to them, it'll be tough to force them to do that. And sometimes, I mean, the proponents of the efficiency of a market will tell you that you need to let the market evolve by itself and not push too much by forcing people to do in a room. But as a principle, I like the idea of some of these shared infrastructure if it makes it more efficient. And I don't see, I mean, it will, of course, ultimately be up to those operators to see how that works best for them in their commercial interests.
Thank you. So we've come to the end of our Business Weekly Series 21, organized by the NBA-SBL. I'd like to thank everyone that has joined us, and thank most sincerely our speaker, who has done fantastically well in throwing up issues with the sector, but also the steps that have been taken to deal with these issues and the challenges and the developments that have come up from and within the sector. Thank you, everyone. Do have a good afternoon.
Thank you, Stella, and thank you for your moderation. Thank you. Thanks, everyone.